All rise. Court of Appeals Division 1 is now in session.
Thank you. Good morning. Please be seated. This is the time set for argument in our case number CV130303, Guarantee Bank and Trust versus Rancho Toscana. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. However, counsel will have to keep track of that time for yourself. We have read the briefs and conferenced this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Good morning. I'm Frank Murray, and I represent the Graff and Ewell families, which have come to be known in the litigation more efficiently as Rancho, named after the company that was used to develop these high-end 46-unit luxury condos that were still are, in the town of Cave Creek. I'd like to begin by making a comment on the construction of the fair market value statutes, the first argument addressed by our opening brief, and ironically, the last argument still being addressed by the bank's reply brief on its own cross appeal. The bank argues now that it was required under statute to, in essence, pull the rug out from underneath the second loan on the theory that the second loan was not secured by the Maricopa and Navajo deeds of trust. You'll find that argument in their reply brief on pages 13 and 14. Ironically, the bank has previously argued that it had the right to engage in such a maneuver because the loan documents gave the bank what it called discretion on how to apply the proceeds of the trustees' sales. But regardless, I have to point out this is a non-issue. The manner in which the fair value of the foreclosed property is considered is indeed controlled by statute, and appellants have every right to expect that the bank will not attempt to subvert those statutes. It's undisputed that the second loan was secured by the first security instruments, also known as the Maricopa deed of trust and the Navajo deed of trust. Why is it undisputed? Because the bank made it undisputed in its own complaint. Please refer to Index of Record on Appeal number 1, paragraphs 34 and 36. As such, the fair market value in the combined properties that were foreclosed via the trustee sale on the Maricopa deed of trust and the Navajo deed of trust must, as a matter of law, be applied to the contracts that were secured by those deeds of trust.
Okay, counsel, technically, paragraph 36 constitutes a commitment by the bank to disgorge or to credit excess proceeds from the sales, right? It says, upon completion of the trustee sales, any net proceeds of such trustee sales will be credited as appropriate against the indebtedness due under the loans. So it doesn't make a specific commitment about fair market value. It makes a specific commitment about if there's excess proceeds from the trustees.
It does speak in terms of excess proceeds, but in the context of a fair market value hearing, that's what the borrower has to rely on. And when viewed in connection with the one exhibit that the bank never introduced, you'll find all the bank's loans transactional documents, I think exhibits like 1 through 32 in the trial. Sitting down there, exhibit 217 is the modification agreement that was executed that indeed allowed the bank to even foreclose and seize the models. And it was a cross-collateralization provision that was meant, and the testimony is uncontradicted and it is perfectly consistent at trial, both to secure the bank's ability against both loans, and to make sure that the assets that Rancho had would be distributed to cover both loans. And that was the testimony unanimously at trial. So you won't see any of the treatment, I don't believe, in the reply brief by the bank of those provisions that exist in the original complaint. This trial consumed, although it's listed as, I think, 19 days or something like that, because of days off, holidays, and at least one rather remarkable building-wide fire drill, consumed a month of trial downtown. Halfway through, the judge DV'd our fraud claim. He was conciliatory, though, pointing out some of this on the record, that we still had all the factual allegations of the fraud to augment our already legally sufficient good faith and fair dealing case. When we discussed how this could occur in the courtroom, we agreed to use the phrase manipulated appraisals. In fact, even more colloquially, we agreed to not use what we called the F word in connection with describing these allegations to the F word, of course, being fraud. And the judge said that he thought this was a fair characterization. He says that on the record during the ruling.
Counsel, let me go back. I don't mean, well, I do mean to interrupt you. Sorry. But let me go back to the business about the application of the fair market value. You said, if I understood you, that the testimony was undisputed, that the cross-collateralization and security was both to protect the bank and to ensure that if there was a default, that the assets, Rancho's assets, would be applied to both loans. Is that an accurate summary? And is that, do you have a reference to that in the, is that the bank's testimony?
No, that's in the testimony of Stuart Graff and David Ewell. It is not contradicted by the bank. And I believe the phrase they used was the assets would be spread over the balances of both loans. That's the language that was used.
And so otherwise, as I understand your argument, otherwise you're saying the bank gets, in essence, a windfall.
Oh, yes.
Assuming that the value of the property is what the trial court found it to be, which was what, 10.5 million? Is that approximately
For the
right?
Cave Creek property, yes.
The Cave Creek property, which exceeded the amount, that plus the Navajo property, the Prescott property, would exceed the value of the two loans. And therefore, the bank, in essence, your argument is the bank gets a windfall because it gets property valued in excess of the loans, of the indebtedness, plus is able to now proceed against the debtors and the debtor and the guarantors for what it claimed on the second loan. Is that a fair summary?
And did, yes.
And did. And the question I've got, one question I have for you is, did you run to any case, Arizona case, that said a bank could decide to do exactly what the bank did here? In other words, foreclose on one note, have a trustee sale on one note or on two notes and not on the junior note when there was cross-collateralization, same bank, same property, cross-collateralization, cross-default provisions, that if one loan goes in default, the other is deemed to be in default, that they could then say, well, we're only going to, when it's under those facts, that the court would allow them to, the bank to proceed on apply the either proceeds or the net, the FMV on to only the loan that was, they had a trustee sale on.
We didn't find any such case. Counsel's probably going to try to convince you that Ludi is such a case. And I would add that this issue, I'm sure you're aware, was the subject of a special action and was exhaustively briefed in the special action as well.
And your argument turns on the fact that there's cross-collateralization. You would agree, I assume, that if there had just been one property sold at a trustee's sale for $10 million. The loan is $8 million. I'm sorry, sold, say, for $5 million. The loan is $8 million, but then the fair market value is $12 million. The bank's entitled to the windfall under that scenario. If there's only one loan, they conduct a trustee's sale. Does the bank get to keep the excess proceeds under that scenario?
Yes, it would under that scenario.
It's
Because there's nothing to return. But
Yeah, but again, it's not excess proceeds, right? It's excess value.
it's excess value. I'm sorry.
Right, yeah, if they actually sold it for more than it was in the loan, then they would have to get the trustee sale. They would have to disperse the excess to.
Quite correct.
Right, but it's the
Yes.
value that we're talking about.
Yes, sorry.
And is there any case that says that?
I haven't found a case on point here, and which leaves to, I suppose, a mild request, and I apologize if this is inappropriate. I'm not in front of appeals courts every day, but if the judge below, and I think he articulated it, and you've probably read it in the record, feels that this is an issue that should be taken up and should be ruled and adjudicated. And I think it's a reason to have a published opinion in this case. I think there is a very real concern that lenders could double up on loans, bifurcate loans, and do things like this that really fly in the spirit of what people think of when they interpret and look at the fair market value statutes. That's just me talking, certainly not my call. It would help, I think, to look at these manipulations that the judge allowed us to introduce it in court, these remarkable triple appraisals that all had the same date of value and all had dramatically different values and different techniques used. Two of them signed. Their own expert admitted that the two signed appraisals are final appraisals, dramatically different in terms of their values. It would help, I think, to look at some of the law of Wells in connection in a very tight way with this case. Wells stood for the proposition that the bank in that case relied too heavily on the literal text of the contract and that the duty of good faith extended beyond those written words. They stated that a party might be injured when the other party to a contract manipulates bargaining power to its own advantage, and that a party may nevertheless breach its duty of good faith without actually breaching an express covenant in the contract.
Is there something that prevents the borrower from getting their own appraisal? I'm having a hard time understanding why an appraisal would necessarily be. That seems like it's just an opinion. The borrower can, if they disagree with that, why can't they just get their own appraisal?
Well, they can, and in a very partial way they tried to here. They obtained an appraisal on, I think, one of the model units from an appraisal company called Countrywide. But the bank's appraisal is the only appraisal that counts. Under FIREA, the FIREA selected appraiser through this blind bidding process that got put in place after the savings and loan scandals of the early 90s, protects this lending process with a very rigorous assignment of an appraiser to a file. And it was testified to by one of the loan officers, in fact, in this case, had told the borrowers, hey, we're stuck with CVRE. You can't go anywhere else and get another appraiser to perform this now, because it looks like exactly the thing that Congress is trying to prevent with this elaborate procedure of selecting an appraiser. We got into that procedure in detail in the trial proceedings, admitting exhibits as to the negotiations between the bank's head of appraisals, a fellow by the name of Mr. Novak, centering on Exhibit 64 and a series of emails where he starts jockeying around with the appraisal figures and, under the guise of addressing the methodology, starts affecting the numbers involved in that process. So there really wasn't any other appraisal that was going to work here. that it had to be the selected appraisal through the FIREA process that operated. Having been stuck with CBRE, CBRE managed to produce 3 different appraisals, and you can bet the only appraisal that made it to my clients was the one that had the low value and the one that didn't respond to the double discounting of their review appraisal. Now, that's an interesting thing that happened here. The bank had a review appraisal done, and the review appraisal uncovered double discounting among other irregularities. That was never told to my clients. They only saw one appraisal, a precisely selected appraisal that was very different from the appraisal that was stamped draft on every page, but nevertheless fully executed and fully signed. Their expert at trial, Jim Sell, testified that that was an active operating appraisal. So now we have 2 FIREA appraisals from the same appraisal service on the same day with the same dative value with dramatically different values. That happened in February. That vastly predates the judge's cutoff date in terms of what he felt was the last date that we could present evidence of good faith and fair dealing. That occurred in like February 12th was one of them, and the other 2 arrived at the bank, I think, on the 18th. They were referred to in the litigation as the morning and the afternoon appraisal. The appraisals themselves all have different ways that they manipulate the numbers, and expert testimony focused on the use of a discount rate that applied a method of accounting for payments over time in such a way that it decreased the interest. It was a bit of a mathematical trick, and our expert pointed it out. It changed the value of the appraisal by something like $2.75 million, if I have that number correct. And their expert, Mr. Sell, took the stand and said that this amounted to a Scrivener's error, that it was a key punch mistake, I believe he said, on the calculator. And the jury didn't buy that, and nobody in the proceeding did. My clients were led down this road starting in February of that year, and long before they got to October, where their expectations for the negotiations to proceed in a good faith and fair dealing manner ran out, they were under the bus by that point in time because they thought their property had no equity. They thought they were stuck with CBRE. Indeed, the bank's loan officers were telling them that they were. I'd like to address, with about a remaining minute that I have here, spoliation, and I'd like to talk about the hung jury issue that still remains, the count 3 that the judge fashioned. And I guess that's the first point I want to make. This isn't something that we presented at the last minute as a good faith and fair dealing claim. This is something that was included in the good faith and fair dealing claim, and indeed the elements of it are all through the joint pretrial statement. But the judge saw it, declared it a classic, that was his word in chambers, example of, and it's in the record, of good faith and fair dealing. And to the relative amazement, I think my counterpart Fred Bellamy would agree, of counsel, decided to bifurcate it and have a second trial on the subject. I want to point out,
Bifurcated it out of your bad faith claim?
he did, and we went to trial on it after we tried the good faith and fair dealing claims, and then that trial resulted in a hung jury. It's a very, and these next 2 comments are just addressing their 7th Amendment argument. He controlled very strictly the nature of that proceeding. He made sure that experts weren't going to testify. He specified that we had 15 minutes aside to present our case, which was done by argument only. No spoliation instruction was given in connection with count 3. he took care to prune back those cross and interrelated claims that I think courts are thinking of when they think of employing Seventh Amendment protections. And again, that's all in the record as well. Just finally on that hung jury issue, it's the issue that remains downstairs that is ironically the issue that caused us to stay that proceeding as we came out here, and it is currently stayed and riding on what nervously I understand doesn't exactly exist anymore, the inactive calendar.
What's the nature of is the nature of the claim, the bad faith and fair dealing, the remaining claim the judge carved out, is that, I had a little trouble understanding that. Was that based on how the bank was going to apply the fair market value or proceeds from the sale?
Exactly.
What happens with that? Let's just hypothetically, what happens if we reverse on the application of the fair market value and say it should have been applied to both notes, to both all the indebtedness? What happens to the bad faith claim dealing with the dealing with how the bank was to apply it?
Well, counsel and I have attempted to work out a decision tree as to all the things that could happen here, and I'm not ducking your question. I would have to, seek advice from my clients, and we'd have to work something out. But we're here without that count, which was pending trial, because I think both of us would agree that it's the tail that's wagging the dog at this stage, and it really is a burden on judicial resources to try to march in and try that thing now in the midst of this. So that's why it's pending and active. I don't know if that sheds any light on your question at all.
No, I mean, it's fine. I just, the idea that you have to talk to your client about it makes sense to me.
Although we have another argument behind you, I'd like to add a minute to both sides so that you have a little bit, if we...
Thank you. I'll reserve my minute.
And then we'll so you'll have 21 minutes over here. All right, thank you, counsel.
Good morning, Your Honors. May it please the Court. My name is Frederick Bellamy from the law firm of Riley, Carlock, and Applewhite, and we represent the plaintiff appellee, Guarantee Bank and Trust. I'm joined by my partner, Scott Jenkins, at counsel table, and my client representatives, Jennifer Austinson and Christopher Erickson, Senior Vice Presidents at Guarantee Bank and Trust. I want to just note briefly to start that despite what we would view as mischaracterizations in the briefing of the issues, that we believe the trial record fully reflects that Guarantee Bank conducted itself professionally, with integrity, and in a commercially reasonable manner throughout the negotiations. With that said, I want to address three areas of legal issues arising in this appeal. First, the fraud claim. Second, the alleged breach of the implied covenant of good faith and fair dealing as applied to the loan negotiations that failed to result in a loan modification. And then third, the fair market value and related issues.
Could you do me a favor?
Sure.
Would you consider arguing the last point first?
Absolutely, Your Honor.
That's kind of how we started with with Rancho. Again, with reference to, let's say, paragraph 36 of your complaint, and whether that constitutes some kind of a commitment from you to apply to give Rancho the benefit of the fair market value if it ended up being higher than you anticipated.
Yeah, I'm happy to address that. As you know, I believe that the loan documents themselves certainly reflect no commitment whatsoever to apply a fair market value credit in the manner suggested and argued by the borrowers here. And I believe there are three basic reasons why the trial court's decision to apply the fair market value credit in the manner in which it did are correct. First, that's a traditional way to proceed when one bank holds both a senior and a junior lien position on two separate indebtedness, as the Southwest Savings and Loan v. Luddite case illustrates. If one bank holds both positions, it certainly can elect to exercise its power of sale on the
That's
senior.
where there was a deficiency, though? There's a deficiency. It doesn't, the fair market value is not greater than the amount of the loan.
That's correct. That issue was not.
And there where, if it's an anti-deficiency, it seems to me that involved a residential real estate where the bank could not go after a deficiency. And it makes sense to keep the loans separate, I think, in that context. But I think we're all curious if you're familiar, if you were able to find any case law that in which the fair market value is in excess of the loan amount, and whether that, particularly where it's held by the same bank, and it seems to be cross collateralization. Are you aware of any cases?
No, Your Honor, we're not aware of any cases throughout the country, frankly, that we were able to find among reported decisions addressing that issue. And that brings me to my second point, which relates to the support that the borrowers are relying on, which is an illustration from the restatement. The restatement itself cites no authority for its position, but our analysis is based on the BT Capital Arizona Supreme Court decision, in which the court made it clear that it didn't consider the restatement authoritative as to the deed of trust statutory scheme in Arizona because it is a creature of statute. It specifically rejected the application of a different restatement provision from the restatement of contracts that was illustrated and on point in the BT Capital case, and noted that this is not, common law doesn't apply when we're interpreting the deed of trust statute. It's purely a statutory scheme. Now, if you look at the restatement's logic, it's solely posited based on the distinction between a single bank and a dual bank situation, saying that in the single bank situation, the fair market value credit should be treated differently than if there are two separate banks. But there's no reflection in the statute of any such distinction. Now, we think the fact that there are no reported cases on this point really shows that the sort of postulated parade of horribles that banks will restructure their loans in order to give themselves a windfall is probably chasing a ghost, in the sense that this issue doesn't really seem to come up. There's no reason to believe it will come up. But to the extent that there were a situation that presented a genuine windfall, meaning real money, real value, then I believe the court in the Mid-Kansas case has already acknowledged at least the theoretical possibility of an unjust enrichment sort of claim in that, based on equitable principles. But here, there is no windfall. I mean, the fair market value credit is a creature of statute created. It's a number created by specific parameters. It's not necessarily the real world result. It's a number, and that number is accorded a special legal significance, and that legal significance was honored and applied here.
But doesn't it at least suggest there's a recognition that maybe the purchase price at a trustee sale may not accurately reflect value? So why isn't that the fair market value number highly significant in this context?
Your Honor, it ordinarily will be, but in this instance, one of our arguments is that the fair market value finding itself was clearly erroneous. Although obviously that's a difficult standard to meet. When you look at the minute entry from the trial court based on the fair market value hearing, a 2-day hearing, the trial court itself observed that the court had never seen such a great disparity between two conflicting appraisal opinions, as in this case, just millions of dollars apart. It stated right in the minute order that it was a matter of credibility, and then it proceeded to attack the credibility of the bank's appraisal based on a flawed methodology that involved using desert mountain comps a luxury community in North Scottsdale in 2006, but not continuing to use those
If
comps.
we're just in deficiency land, if the fair market value assessment is still results in a deficiency, you agree that the deficiency is calculated based on the fair market value?
Yes.
And not the
Yes.
price that the trustees
Yeah.
feel. So that
Absolutely.
number is important, and
It is important.
And so if it turns out that number is much higher than the loan value, that's the dilemma we face. What do you do with that excess value?
One of the other related issues that we raise in our brief is, and this relates to the earlier questions, Your Honor, about the nature of the breach of the implied covenant claim related to the application of the fair market value credit. First, we don't see that there was a discretionary act in the application of the credit. Instead, that's simply a matter of statutory interpretation. I mean, we are, the bank is either correct in its interpretation and the trial court is either correct or not, but there's no contractual discretion involved in that analysis.
You're saying that the statute requires you not to apply the excess fair market value to the second loan?
Not exactly, Your Honor. What we're saying is the manner in which we conducted the deed of trust sales, because we could have achieved the result that the borrowers are arguing for by foreclosing on the junior position, which would result in.
But I mean, in essence, even in your complaint, while you don't talk about fair market value, in the complaint, the verified complaint, you said that you would take the net proceeds and apply them to both loans, to all the indebtedness. I mean, isn't that a commitment that if the net proceeds are less, that we're going to do the same thing with the fair market value?
No, I don't believe so, Your Honor. The manner in which the deed of trust sales were noticed reflected the indebtedness on the term loan.
Yes, but you noticed the bank noticed all the indebtedness.
That's correct.
It just had the trustee sale dealing with the two notes on the first loan.
Right.
Or the two deeds on the first loan. So I understand that, but let me get back. Because I want to stay on track on this. So I'm on track on this. There are two questions I have. First, you said that there were three reasons on the fair market value issue why the court was correct in not applying the excess fair market value to the other indebtedness.
Yes.
And you did two. I think you did two of them.
Yes, that's correct, Your Honor.
So I just wanted to make sure you got. I understood what your third reason was.
Yeah, and the third reason is that the statutory scheme provides for an opportunity to object to a deed of trust sale. It was properly noticed. The borrowers did not seek an injunction under ARS 33811C.
Of course, they're not arguing on how the sale occurred. They're arguing about what you do with the proceeds.
Yes.
Okay. So
I think it's worth noting that if the court were to reverse the fair market value finding of the trial court itself, then it may not be necessary to reach this issue, depending on the result of a new fair market value hearing. And also, to go back to your earlier question, Your Honor, I mean, I believe that if the court did reverse the trial court's interpretation of the statute and applied the fair market value credit to both loans, that would render the second bad faith claim moot, which I also believe reflects that we're not really talking about contractual discretion unless you're looking at the manner in which the loan remedies were enforced as a discretionary act.
The other question I had was your opposing counsel said that the testimony by the Rancho witnesses was undisputed, that the cross-collateralization security for the two loans at the bank's request was done in part so that the assets would spread over to all the loans. Is that undisputed? Or is there evidence?
In terms of the oral testimony of witnesses, yes, but the reason for that is that Guarantee Bank is not the party that negotiated those changes to the loan agreement, but we would not characterize the issue as undisputed because the contractual documents themselves don't reflect that. And the contractual documents assume knowledgeable parties, the fact that if they misunderstood those terms, that's a different issue. Also, the contracts are drafted with the statutory scheme implicitly in mind and implicitly incorporated. So we would say that there couldn't be a bad faith claim because the loan contracts.
I understand that, but you're just, but my question goes more to, so the evidence was that, the oral evidence was that, undisputed, that the reason for the cross-collateralization was to spread the assets over all of the loans, but you're saying the contract documents don't say that when it comes time to foreclosing or having a deed of trust sale, that you have to apply. It doesn't say either way what you're going to do with it.
Right. What is undisputed is the borrower's statements of their understanding of the purpose, which we don't view as particularly probative or relevant.
But the contracts don't say either way. They don't say, okay, we're going to apply it only to this loan, we're going to apply it both ways.
And we view the cross-collateralization as simply reserve the bank's ability, the lender's ability to reserve its discretion in terms of electing remedies.
Okay.
I'd like to address the fraud claim, if Your Honors prefer. There are three alleged misrepresentations that go to fraud. As the court is well aware, there are 9 elements of fraud under Arizona law, and they must be proven by clear and convincing evidence. The failure to prove any one of those elements is fatal to the claim. We actually believe that they have proven 0 of the 9 elements as to all 3 misrepresentations. I'll take them one at a time. The first one is this bulk valuation representation, which is significant primarily because that's the only communication that is actually attributable to Guarantee Bank. But there's a written exhibit in which the bank explained its how it worked. Bulk valuation basically applies when a bank forecloses on a large development, such as this one, 42 empty lots and 4 models. The bank explained in the course of negotiating and discussing a potential loan modification with the borrowers that whether the bank applied bulk valuation to the 42 lots, which is logical and required because the bank is not reasonably going to be expected to sell off 42 individual lots to retail buyers. They're going to sell to another developer. But the bank's communication was whether it took those at bulk value and took the 4 model condominiums at retail value and added those 2 together to provide the valuation for underwriting purposes, or whether it applied bulk valuation to the entire property as a whole on the assumption that it would be sold in bulk to another buyer, that it made no difference to the bank either way in terms of the fact that it was underwater. The loan-to-value ratio was too high. It was unacceptable. The bank needed more collateral and was insecure thanks to the depreciation in
something like 95% or 86%
Yes.
difference between the two.
Yeah, that's exactly right, Your Honor.
Yeah.
Moreover, this was in the course of stating the bank's intention as to the potential of a loan modification that would roll the original $8.5 million term loan into a new loan that would be created that would also cover the construction costs for the vertical financing of future units. So again, there was a logic to applying the bulk valuation. First, it's basically true. It's to the extent it's a statement of the bank's intention as to how it was looking at a proposed loan modification. It doesn't qualify as the kind of representation that's actionable in fraud. There's no falsity, certainly no notice of falsity, no right to rely. And in terms of what was reasonably contemplated by Guarantee Bank in making this communication, the borrowers are arguing that the bank wanted to lock them in to only dealing with Guarantee Bank. Well, the record is completely contradictory to that fact. Guarantee would have been more than happy to see the borrowers refinance through another lender. They raised that possibility at several points and included a very substantial discount early on in the negotiation, saying we'll take essentially $2 million off your debt if you want to go refinance it with someone else. That's certainly not consistent with clear and convincing proof that the bank intended some kind of reliance so that they would feel like they were married to Guarantee Bank. Just the opposite, and the trial record reflects that. The other two alleged misrepresentations both relate to the CBRE appraisal. The first is this alleged double dipping of entrepreneurial profit and the discount rate. My learned colleague has pointed out that the bank, that after the borrowers had complained that they didn't believe the appraisal, they'd submitted to the bank their own appraisal from Countrywide, that Guarantee, undertook voluntarily to go the extra mile to send out the appraisal to an independent reviewer who does review appraisals. He commented on the methodology. He's the one who flagged the double dipping, double counting analysis, and he communicated that directly to CBRE. CBRE responded. They made their adjustment. Their adjustment actually reduced the value of in their professional opinion, by $30,000, which Guarantee, said was basically immaterial. It was an insignificant change. But the bottom line is, these are not representations by Guarantee. They're representations. They're a professional opinion. There's no right to rely on those opinions. And it certainly doesn't qualify in terms of falsity, knowledge, materiality, right to rely, or any of the other 9 elements. So we think the court was quite correct in granting directed verdict on the fraud claim. That said, I will note from a procedural point of view, to the extent this case raises Seventh Amendment issues, if there were a reversal on the fraud claim, the borrowers have clearly stated in their brief repeatedly that they essentially piggybacked those allegations into their bad faith claim related to loan modification discussions, and so presumably those claims would have to be tried to the same jury. Turning briefly to the breach of the implied covenant of fair dealing claim related to loan modifications, I want to point out that first, this is a fundamental departure. Their argument represents a fundamental departure from basic principles of contract law, because what they're basically arguing is that there are 3 duties that arise in this case from the implied covenant. One, some kind of duty to modify the loans in the first instance. That's not true. The loans themselves expressly disclaim any obligation, commitment, expectation, promise to even consider a loan modification or any extension. Of course, any modifications to the contract had to be in writing under its own terms and under the statute of frauds. So that duty just plain doesn't exist. The second duty that they allege is some kind of duty to have offered and agreed to terms that the borrowers themselves unilaterally deemed reasonable. There's no such principle created by the implied covenant or otherwise. I mean, parties are not entitled to get the contracts, new contracts, according to the terms that they want. I mean, that said, I think the record reflects that the terms that Guarantee were offering were reasonable, but the borrowers clearly didn't like it.
Is Rancho asserting that there was an oral agreement to modify, and that the bank then backed out of? Was that part of what was argued, that we did have an agreement? Is that what was presented to the jury? As to whether they argued it, it's a little hard to say, because on the one hand, they did point at trial to a statement by Guarantee, we have a deal, after they had signed a term sheet outlining basically the contemplated deal. That term sheet itself noted that there's no deal until you sign on the proverbial dotted line, that it wasn't an offer, commitment, or anything like that. But even beyond that disclaimer in the term sheet itself, even today, the borrowers are complaining about terms on that term sheet that they agreed to, including the $250,000 exit fee, interest rates, number of spec units. I mean, they still are arguing that those terms are unreasonable and unacceptable. So in what calculation there could be
an oral agreement, notwithstanding the statute of frauds, notwithstanding the language of the contracts. I don't understand, but there's certainly no obligation to agree to terms preferred by the other party. I'm out of time. Thank you.
Thank you, counsel.
Just a few things with my minute. First of all, counsel introduced his clients. I should point out that my clients are here as well. On to more substantive matters. They noticed all 3 deeds of trust for sale, Maricopa, Navajo, and Master. On the sale date, they just ignored the Master deed of trust sale, and they never filed a cancellation notice. Rancho had no idea what was happening with those trustee sales as a matter of notice. Secondly, on spoliation, which we really haven't testified about very much, we have some content in their final brief about the $39.1 million appraisal. And I want to point out that all of that testimony from Jennifer Ostenson that's presented as if it is not an appraisal and it was a placeholder in a corporate form that somehow showed up 3 times in the same corporation is not testimony that was ever presented to Judge Anderson. He made his judgment on the basis of a spoliation hearing that occurred long before the trial. This is a story that was prepared as a result of her own research that she presented at trial. And with respect to the comments of counsel about these deal points, the exit fee that was created, the deal points that the Graffs and Eels were somehow complaining about, we didn't know what had happened with respect to this case with those appraisals until Judge Burke appointed Judge Schwartz as a special factual master, and we got a bunch of orders, and we found out much later that those appraisals had existed. So the timeline is a little out of whack. Rancho had no reason to believe that they had so much equity in the property that was recognized by CBRE that was being tooled with by the bank with things like exit fees that are designed to keep you operating within the same bank. That's
Counsel,
it.
you could refresh my recollection on something. On the application of the fair market value, I think your argument in part in your briefs was that when you read 33814, application of the fair market value, in light of the definitions of contract and credit bid, that would seem to imply that you need to apply it to all debts.
Yes.
At least I guess in this situation, as opposed to Ludi, where there is a credit
A different set of facts.
and a credit. I mean, there's a surplus in value and cross collateralization, which wasn't present in Ludi.
Yes.
Okay, thank you.
Thank you.
Thank you, counsel, for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.